Actually, my first or second.
So how do we want to run this now, Samuel?
I don't know. We can talk a bit longer if you want. Because initially I thought of doing 15 minutes each.
Sure.
But if he's not showing up, we can make it 20
reflection. Well, yeah.
And then we have some.
Are you ready for some questions?
I have some questions, but I don't
I think for
know.
webinars, questions are better than lectures.
We assumed that he was going to be here. We
Yeah.
didn't want to take too many questions from the audience because we have not too much time. But if we have a bit more of time,
Yeah.
and if I am handle to see it from here, because I can also pick up a few, and then you can react to Samantha as well. We might have a question.
Samantha's role exactly as well.
Not ATUI, ITUC.
ITC.
And she's the director of the Just Transition Center. Yeah. So yeah, we can pick up a few questions then from the chat if he's not coming.
Let's,
Yeah. Maria, shall we start? Because,
yeah, I can just.
or you want to wait all 5?
No, it's fine. I'll take it over and you.
Welcome everyone to our hybrid event on Ecocide, a new path to address environmental abuse. My name is Mehtap Akgüç. I'm a senior researcher at the ETUI, and I will be moderating the event today. So we are going to talk about a very relevant issue that is called ecocide. And it's particularly relevant basically in the aftermath of COP26 that just ended a few days ago. So I think that the moment to talk about this issue couldn't be more appropriate than now. And for those of you like me who are not necessarily legal experts, you may wonder what ecocide actually means. Well, a few months ago, an independent expert panel came together to discuss and come up with a legal definition of ecocide. And according to this panel, ecocide means unlawful or wanton acts committed with knowledge that there's a substantial likelihood of severe and either widespread or long-term damage to the environment being caused by those acts. So this is a way to hold accountable those who cause damage to the environment. But this is quite serious stuff. And if this definition is actually adopted as another crime in the International Criminal Court, then ecocide would officially become another offense, almost at the same level of gravity as genocide or other war crimes. So therefore, it has major implications for people, for organizations, and for countries as well that commit ecocide, and also those who are affected by it. So to enlighten us about this whole concept and to discuss its implications exactly, I'm really pleased to be joined by excellent speakers today. So I'm going to start with Philippe Sands, who is a professor of law at the University College London. Philippe has co-chaired the independent expert panel for the legal definition of ecocide, and he has also acted as counsel in a wide range of areas, including maritime boundary, international trade disputes, genocide, as well as claims related to natural resources and pollution. Then we have Samantha Smith, who's joining us remotely today. Samantha is a lawyer and activist and the director of the Just Transition Center as part of the International Trade Union Confederation, ITUC. And she previously worked as global climate and energy leader for World Wildlife Fund. We also expect to have Samuel Cogolati, who is still not here yet, but perhaps can join us later on, and who's a member of the Belgian Parliament and from the party Ecolo. And so now that we don't have him, I think I'm just going to start with Philippe. Philippe, I'm going to pass the floor to you right away. Please tell us about Ecocide and how did you and your colleagues come up with this definition and what kind of thinking went behind this? So.
Well, thank you very much for inviting me. It's very nice to be here in Brussels at the ETUI. It's my first visit and I hope it won't be the last. I want to give you a little bit of context and background so you can situate this in its broader framework. As of 1945, there have been 4 international crimes. The oldest one is war crimes, 19th century invention. And then we've got a sign saying, are people not hearing well? Are we sure that the microphone is okay?
No, it's okay.
Okay, good. War crimes, and then 3 invented in 1945 in the context of the creation of the International Military Tribunal at Nuremberg, the famous Nuremberg Tribunal. Crimes against humanity, destruction of individuals, genocide, destruction of groups, and the crime of aggression, as it is today called, waging illegal war. All 4 of these existing international crimes, and there have been no new ones for 75 years, focus on the protection of the individual, the human being, for obvious and very good reasons. None of the international crimes as such focus on the protection of the environment, because of course, in 1945, the environment was not part of the international legal order or of political consciousness. That began to change in the 1970s. The Vietnam War and the use of napalm caused an American academic to, it seems, be the first person to coin the phrase ecocide in around 1968, 1969. And in 1972, at the first UN conference on the human environment, Swedish Prime Minister Olof Palme evoked the need to use international criminal to protect the environment. Nothing much happened. It sort of floated around as an idea. And then in 1998, at the Rome conference to negotiate the adoption of the signing of the Statute of the International Criminal Court, there was more discussion about a new 5th international crime of ecocide, but a majority of countries thought that the time was not right, that there was enough to do with creating a permanent international court. It was a 50-year project, and this was significant enough as a burden. So after 1998, the International Criminal Court came into being in 2002. So we'll celebrate its 20th anniversary next year. It's had a mixed start. In my view, it's not been wildly successful. Reflect on why that is on another occasion. And starting really in the 2000s, led by a very interesting English barrister called Polly Higgins and her colleague Jojo Mehta and various other colleagues across Europe and the world, the push came through civil society to fill the gap, to move to a 5th international crime, the principal focus of which is not protection of human beings, but the protection of the environment. And Polly Higgins and others came up with various definitions. But it seems that by 2020, there was a sense that there was a need to refine the definition as a draft working idea. And in the autumn of 2020, the Stop Ecocide Foundation received some grants to do some legal analysis and thinking and come up with a definition of the crime of ecocide that could be inserted into the statute of the International Criminal Court. And I was one of the 12 or so people who were invited to join a working group to elaborate a draft definition of ecocide. Our terms of reference were clear. It was to come up with a text that could be slotted into the statute of the International Criminal Court. That's important to say at the outset, because it means that our focus was only on individual criminal liability, not on criminal liability of corporations, not on criminal liability of states, because the ICC only has jurisdiction over individuals. And secondly, it inspired us obviously to work towards a definition which drew on the language and approach of the existing ICC statute. It's important to say that because that puts in context what it is that we have done. The 12, happily, was a very mixed cast of characters, which I'm strongly supportive of in terms of gender and nationality and ethnicity, and also, frankly, political and ideological views. At one end of the spectrum, we had what one might call fundies, absolutely committed to going as far as you possibly can. At the other end of the spectrum, you had the realos. Look, we've got to get states persuaded, and the only way that we can do that is come up with a definition that is more restrained. But very early on, we worked together for 6 months. I co-chaired it with a wonderful Senegalese jurist, Dior Sao-Fallo, and we agreed we would do all we could to come up with a consensus text. We didn't want to have a majority report and a minority report, because we knew that the moment that happens, the project is lost. You've got to have a consensus. If these 12 people can come up with a consensus, then it has a better chance to run, given the spectrum of views. And I'm very pleased to say that everyone was very consensual and collegial in their approach, so that the definition that we came up with was one that we all agreed with. And we all signed it, and we all put our names to it, and we can email to you later the official commentary that we did. And I'm going to say a little bit about the process of elaboration. Let me just say also, just speaking personally, why I decided to do it. I had been watching developments. I taught international environmental law since 1989. I taught the first ever course on international environmental law in the United Kingdom. I had been inspired by the Chernobyl accident in 1986. I'd never taken a course on environmental law, domestic or international, and it was not part of the international law curriculum. I remember having a whole discussion with the famous British international law professor, Ian Brownlee, who'd written the main textbook on international law, Brownlee's Principles of Public International Law. Ian, why don't you put a chapter on the protection of the environment into your book? And this was about 91, 92. And he said, because it's not part of international law, Philippe. It's not part of international law until the International Court of Justice says it's part of international law. 5 years later, in 1996, I was part of the delegations for the South Pacific small island states, Samoa, Solomon Islands, Marshall Islands, Micronesia, that persuaded the International Court of Justice in the advisory opinion on the legality of the use of nuclear weapons to include a paragraph 29 in this advisory opinion saying the protection of the environment is now part of the corpus of international law. I actually feel quite proud about what our little group achieved, because obviously strong opposition from the 5 permanent members of the Security Council, but the court said, no, we put it in. And so from that point on, Mr. Brownlee changed his textbook, and international environmental law really took off. I had been a bit skeptical about the use of the criminal law at the international level. But what really convinced me, frankly, in the autumn of 2020 was the attitude of my children, because they all are very focused on issues of climate change and ecology in ways that my generation was not. And I felt a responsibility as a parent, as someone from my generation who's left the world in, frankly, a pretty fucked up state, to just do more. So there was that was really important. It was interesting when the Guardian newspaper ran a piece saying this group had been established and I was on it and co-chairing it. It's the only time in my life that all 3 of my children who are in their 20s WhatsApped me and said, oh, Dad, finally you're doing something useful, which I thought was very interesting. So the enthusiasm of younger generations to me is a very big motivating factor. And the other motivating factor was the work that I'd done on international criminal law. I'd done a lot of cases on crimes against humanity and genocide. And I'd written a book in 2016, East-West Street, Retour à Lemberg. I'm actually doing an event on in Beaux-Arts later this evening, reminded me of circumstances in 1945. In a time of crisis, these two remarkable individuals, Hersch Lauterpacht and Raphael Lemkin, who coined the concepts of crimes against humanity and genocide, did not curl up in a corner and weep. They got up and they used ideas and changed the world with their inventions. And I felt that is inspiring, and we have a responsibility to do the same thing. So what did we do? I have to say I drew from my own experience. I do a lot of cases before international courts. I've done cases at the International Criminal Court. And the golden rule for this kind of stuff for me, there are two golden rules. One, keep it simple. And the more complex it is, the less likely it is to get off the ground. Second, less is more, or the best is the enemy of the good. We're not going to come up with something that's perfect and will please everybody. So we need to find some sort of center of gravity. And a third aspect of it that was extremely important for me personally was to sever the connection between international criminal law and an anthropocentric approach. We must come up with a definition in which you do not have to prove harm to humans to sustain a possible international criminal act. It has to be focused on the protection of the environment. And in that, I just want to pay testament to a very inspiring figure for me, someone I knew quite well, who passed away this year, an American scholar called Christopher Stone, who'd written a fabulous law review article in 1972 called Should Trees Have Standing, which really posited for the first time in a really comprehensive way the idea that protection of the environment is an end in itself. It is not a means to another end, namely making the world a better place for human beings. And this was something also, I think, that we've achieved. So we came up with a new draft Article 8 ter, T-E-R, to insert into the statute. We took the view that we could not simply put it under crimes against humanity, because that would focus it on the protection of human beings. And the genocide threshold was too high. To prove a genocide, you have to prove an intention to destroy a group in whole or in part, and no one intends to destroy the environment or in whole or in part. It is always an unintended or incidental consequence of some other social desire to act in a particular way. So in essence, the concept of ecocide takes the clothes of the term genocide, uses the innards of the concept of crimes against humanity, and then places it in its own separate fifth crime category. And we came up, I think, with a very simple, workable text. For the purposes of this statute, ecocide means unlawful or wanton acts committed with knowledge that there is a substantial likelihood of severe and either widespread or long-term damage to the environment being caused by those acts. Just a few brief points. There is in this a double threshold that we have created. And bear in mind, we're concerned here with an international criminal definition. So it's got to set the threshold high. There's huge amounts of environmental damage taking place in every community, literally in the world. We have to create a reasonably high threshold. Firstly, the damage has to be either severe, it has to be severe and either widespread or long-term. Widespread has a geographic element and long-term has a temporal element, and it's not cumulative, it's either or. Severe, widespread and long-term would have excluded the purely local destruction, for example, of an ecosystem, whereas severe and long-term allows you to catch a localized destruction, for example, of an entire rare ecosystem. And secondly, the second threshold requires that proof must be established that the acts are either unlawful or wanton. And we went for those alternatives for the following reasons. Firstly, we needed to set a second threshold. Just significant harm to the environment is not going to be good enough because there's a lot of significant harm. So it also has to be unlawful. And unlawful means either at the national or international level. It can't only be international level because there are very few things that are unlawful internationally in relation to protection of the environment. And it can't be only unlawful at the national level because all the state would then have to do is make legal the destruction of the Amazon rainforest or whatever it is. And then all of a sudden, it's not gone above the threshold. But illegality is not the only element. The alternative element, because it could be lawful, is wanton. And wanton here has been defined as follows. Wanton means with reckless disregard for damage which would be clearly excessive in relation to the social and economic benefits anticipated. And there's been a bit of criticism of this text. I understand that criticism. I very much understand that criticism. And the criticism is that we've introduced a balancing exercise, which is actually one other point that I'd make on the fourth golden rule is every bit of this definition must be drawn in some way from an existing principle of international criminal law so that we can say to states, we're not really doing anything so new here. There is precedence. Countries, governments are extremely conservative and reactionary, and if it's not been done before, they're unlikely to jump at doing it. So every bit of the text, we can say, oh yes, but there's Article 13, Article 7, it uses the same approach. And in war crimes, there's a balancing exercise when you're looking at the targeting of military targets and incidental damage to civilian targets. There's a balancing exercise that takes place. And the balancing exercise here is on the one hand, harm to the environment, and on the other hand, social and economic benefits anticipated. And that's been criticized as being too anthropocentric. But we faced a real political reality, a very real political reality. The world is not an equal place. Countries are in different stages of economic development and well-being. And the simple fact is that if we're going to get through the statute of the International Criminal Court, we're going to need the support of a large number of developing countries. And unless we put some modifier in there, there was no prospect of getting developing countries to come on board. A pure environmental damage definition would have excluded us from taking this forward. So that's roughly what we've done. There's a lot of questions I know that could be asked. I'm really looking forward to hearing from Samuel, because very happily, amongst one of the consequences, I really am happy about it. Very meaningful to me, apart from the Secretary General of the UN running with the definition, saying the statute should be amended, and the Pope and various political leaders. It's very satisfying indeed to be in Belgium, whose Foreign Affairs Committee of its parliament has adopted last week a very important recommendation to run, or to cause the government of Belgium to run with supporting an international proposal, which is based on our definition. And that means a lot to me. Maybe you can say a little bit more about your thinking about that. Final thing, what happens next? It all turns on governments. There is something called the Assembly of State Parties, which is part of the International Criminal Court, and we have to persuade 80 countries out of 123 or thereabouts to run with a proposed amendment. I think that is doable. I'm pretty optimistic. It's not a question of whether, it's a question of when. I don't know whether it'll take 1 year, 3 years, 5 years, 10 years, but there is plainly something that is happening. And particularly, I think, after the failure of COP26 to do the necessary over this past weekend, I think people are going to be looking for other means to fill the gaps. So there are grounds for optimism. One final word, I am not for a moment starry-eyed about the mere fact of adopting this text somehow changing human behavior. Genocide became a crime in 1945. The genocides did not stop. Crimes against humanity became a crime in 1945. The crimes against humanity did not stop. But what changed was that human consciousness changed. And that is the most important thing about this project. It is about getting us to recognize we are limited in what we can do to our environment, and international criminal law is one instrument for changing consciousness and telling us if we misbehave, we risk being punished as individuals. Let me stop there and pass it over to the rest of the team.
Thank you. Thank you very much. This was very enlightening indeed, and also for the historical evolution that you provided was very, very interesting. Thanks a lot. And let me complete the introduction as now that you joined us, Samuel. So I just said you're a member of the Belgian Parliament from the Party Ecolo, and you are an activist fighting for human rights and just transition. And more recently, you have also been involved and advocated for the recognition of Ecocide, as Philip said, in the Belgian Parliament. So please tell us about your experience in Belgium a bit, and also your activities and your perspectives about this whole issue.
Sure.
The floor is yours, about 15 minutes.
Yeah, well, thank you so much for your invitation. You don't imagine how happy I am to be here over lunch with you to speak about Ecocide. It's been a very long political battle. And so I'm very proud to be here with you and to be able to speak about the crime of ecocide when we just actually adopted this resolution. It was last week, Tuesday. So it's very recent, and you see how timely the topic is. And second, I'm also extremely honored to be on the same table as Philip Sens. I have another life in when I was a PhD student in international law at the University of Leuven, and Professor Sens has always been a real model for me. I've read his books, and so it's really amazing to be able to debate about this crime of ecocide with the culture of this panel. But let me maybe come back to the political history, because that's what interests me, is maybe this more policy perspective on this new topic. Because I must tell you, 2 years ago, I was fighting for the recognition of ecocide, and people, even within my own Green Party, were making fun of me, like saying, you're coming up with this new, okay, great idea, but what is that? It's so abstract, it doesn't mean anything. It doesn't even have a legal definition. It's not even an international crime. So what is that about? And when I started drafting my proposal of resolution, I requested the help of the library, of the official library of the parliament. And I asked them, please, can you find any kind of traces of ecocide in parliamentary debates, even in questions to the government? And the library answered, well, sorry, but we don't have anything. Like, there was not even a question asked to in the Belgian parliament about this new crime of ecocide. So very frankly speaking, the idea, and I need to acknowledge that, was really much coming from the civil society movements. And it's true, you've been speaking about Polly Higgins in the UK. In France, we've been very much influenced by the movement around Valérie Cabanès, who's a French jurist and activist. And that's important to say, because there is indeed, as you said, a tension between this very pragmatic, realistic approach of lawyers, but there is also a very, how would I say, a push towards even objective responsibility in criminal law, which would go too far, I think, but we can debate about that later. But so the idea really came from the civil society. And Valérie Cabanès came to Belgium in July 2021, so it's a bit more than a year ago. And we submitted for the very first time this proposal of resolution in the Belgian parliament for the recognition of ecocide. Back then, at the time, we didn't have a government, which is quite usual in Belgium. You know that we have elections, but then it takes years before we can form a government. Some people know, maybe here in the room, who are used with Belgian politics, is always big debates between the French-speaking and the Flemish parties. But in September 2021, we finally were negotiating the final run of a new federal government with Christian Democrats, with the socialists, with the liberals on the right, but also with the Greens. And we made it a priority to recognize this new crime of ecocide, not only in our own criminal code at the domestic level, but also at the international level. And we made it. So in September 2021, a bit more than a year ago, we were able to set in the program for the next 4 years of the current government of Belgium at the federal level, we made it to pledge to recognize ecocide at those 2 levels. So you need to know that at the domestic level, we set up a panel of experts, our own domestic panel of experts, chaired by Professor Damien van der Mesch. I'm sure you know him in international criminal law. And at the international level, we made this pledge of pushing towards an amendment of the Rome Statute. And I must say, and I'm quite positive and optimistic, all parties were actually agreed to make this pledge reality. In December 2020, it was the Minister of Foreign Affairs. She was the former Prime Minister, Sophie Wilmès. And she's a liberal, but she was intervening in the ICC Assembly of State Parties. And for the very first time, and I will take some water if you want, that would be fantastic. Otherwise, I will lose my voice. But for the very first time, Belgium actually proposed to amend the Rome Statute and to recognize this new international crime of ecocide, like war crimes or crimes against humanity. A bit, thank you. In May of this year, so you see it's a beautiful history. It goes with stages. And in May of this year, I have the honor to chair the Belgian delegation to the Interparliamentary Union. So it's basically the assembly of all parliaments in the world. And we were discussing an important resolution of the IPU, a universal resolution on the fight in parliaments against the climate crisis. And I thought, well, maybe we could try an amendment to this resolution in paragraph 31, and we could maybe try to invite all IPU member states, so basically all parliaments of the world, to recognize this new crime of ecocide. And so I tried first with the group of European states and some like-minded states, and every delegation was basically agreeing to that. They were like, okay, why not? Yeah, let's do that. Okay, we'll support you. I only got the opposition from 3 states: India, Nicaragua, and Turkey. But all other countries accepted. And so we passed this resolution for the first time at the universal level, even if, okay, that's not the most important international organization, but it's one of the oldest of the international system. So that was also an interesting step forward. And then came the new legal definition of the panel co-chaired by Philip Sands. And that was a very decisive moment, extremely important, because for the first time, we could say, well, we can refer to some kind of universal legal definition agreed by top lawyers from
reasonable human beings.
Reasonable human beings, but also representing all continents. And that was important. And so we thought, well, maybe it's the good timing to try to move forward our own proposal of resolution. Because it's something to deposit and to submit a resolution. It's another thing to put it on the agenda and to go to vote. But we thought, well, with this new legal definition, let's try to do that. And we submitted an amendment on our own resolution, actually referring to the new definition of the panel. And we said, well, we need to recognize that. We need to recognize this new legal definition, formally speaking, in the parliament of democratically elected people. We need to press for a new international agreement at the universal level. Why? Because we thought, well, the ICC Rome Statute is okay and would be nice to amend, but you need 2/3 of the States Assembly in order to amend it. And so we thought, well, maybe we could go a bit faster and initiate this ad hoc international agreement with the most voluntaristic states like Belgium, probably a few island states, which are confronted with the sea rising. And third, we also want to, of course, amend our own criminal codes, still on the basis of this very same definition. And I'm very happy to say that after some months of discussion and debate, we were able to approve this resolution last week on Tuesday, and it will be accepted in its final form by the plenary assembly on the 2nd of December. So Thursday.
You think it will be accepted?
Oh, that's for sure. Politically speaking, we have an agreement, so that's for sure. On the 2nd of December, the plenary assembly will accept this text. And so it's an important move, and I think, and I believe it's good news, because once again, some months ago and some years ago, people were making fun of me, and now you see that you can actually press for some change within the parliament, of course, thanks to the help of civil society, but also of legal experts. Now, maybe just to conclude with not bad news, but I would say some dangers and some opposition we could be facing. The first element, and I hope there are not too many Belgians listening to us, but it's the governmental agreement is actually very badly drafted. It's something we negotiated after days and nights of negotiations, and in order to approve this phrase referring to this crime of ecocide, we refer to an awful definition, la destruction délibérée des systèmes écologiques, so the deliberate destruction, which is stupid. I mean, you're never going to deliberately pollute the environment just for the pleasure of polluting it, right? So we have this problem, but that's a real problem. It's the moral element, the mens rea, and we really need to make sure that in the definition we will adopt in the future in our old criminal code, but also in the definition we will refer to in the amendment of the Rome Statute, we need to make sure that we have this more, I would say, pragmatic, less artificial understanding of the moral element as proposed by the panel. That's one danger. The second challenge on the material side is the translation in our civil law system of wanton acts. That's a challenge. I would translate it by act arbitraire. But even that is difficult, to leave so much to the judge in a criminal system which likes to stick to this principle of legality. That will be a challenge. And we will need to translate that in our legislation. And finally, two kinds of opposition we will be facing, and we have been facing in the adoption of this resolution. It was adopted by every single democratic party, but rejected by the far right, which is always an honor. When I have a text of mine which is refused by the far right, I always think, well, that's good news, that's very good, but also refused by the nationalistic Flemish side, so NVA. But besides, all other parties have agreed and approved this text. But something that came up very, very often was this idea that by recognizing a new international crime of ecocide, you actually diminish the importance of crimes against humanity and of genocide. It may be ridiculous, but you need to know that in political debates, at least here in Belgium in the parliament, that's an idea you often hear, and that we need to confront. And I have heard that argument over and over, and so we need to be aware of that. And second, and that's maybe more technical and of less importance at the global level, but in Belgium we have a federal state with regions actually entitled to rule and legislate over environmental issues. And so there is also a potential challenge here with Flanders, and you know how they like preserve their, constitutional powers. Well, there is a challenge here that Belgium wouldn't be entitled at the federal level to rule over this new crime of ecocide. Of course, I have very good legal arguments, and we can go on and on this issue. But I think that's also a point of interest. So this is it. In conclusion, I really think that this battle was won thanks to really this wonderful civil society movement, extremely broad, extremely ambitious, with the legal experts mediating between the very high ambitions and the legal reality. And then political, elected individuals in the parliament willing to press for change. And this is, I think, a good example that, parliament sometimes, it's not always pink and beautiful, but sometimes if there is a strong will, we can actually press for change, and that's a good example of it.
Thank you very much, Samuel.
Could I just ask one very quick question?
Okay, because we have to really give the floor to Samantha.
But in the group, there was a big debate, the legal group, about whether to include certain crimes in a list. And the majority of the group in the end said no. I was very against listing particular crimes, particular acts, because my sense was the moment you have a list of crimes, you're firstly saying that things that are not on the list are all fine, and no list is ever going to be perfect. But secondly, and even more significantly, the moment you have a list, you create the opposition. Every single act that is in a list will have opponents for all sorts of reasons. And so I think we took the wise decision at the international of going down this path. Does that work at the domestic level? And have you heard calls, Nisi quoi, what is it? We need to have examples. And how are you dealing with that?
Well, I had, of course, the same question. And so it's really funny because we've been through all the same debates over and over. Not only the list, but also concrete examples. Yeah, but please, could you list in the law concrete examples of, is Chernobyl an example of ecocide? Is Fukushima? But that doesn't make any sense. You're not going, I mean, for example, on the crime of torture, of course it's, forbidden and it's criminalized. It's a criminal offense in our domestic legal system, but you don't give concrete examples in the criminal code itself. You're not just going to explain how you're going to take the nails and so on and so. And we'll close the discussion here. But so exactly as in the case of torture, no, you should be able to give a legal definition that is broad enough to encompass all acts of very severe and serious damage to the environment, which can be understood as ecocide. But it's true that's again a big challenge, because some people were in favor of detaining all kinds of those environmental damages. But I also think it's a bad idea.
The third element of it was that if you were going to have a list, you could not leave off the list climate change. But the moment you put climate change in it, the project is dead, because no government is going to have spent so much time negotiating under the Climate Change Convention and COPs and so on and so forth. And then all of a sudden, through the back door, criminal law comes in and just says, oh, you can't do all of this.
Exactly.
It was dead.
Okay, we really have to leave the floor now to Samantha. And I'm actually very curious. It was really excellent overviews, the Belgian experience, but also the international and all that debate. But I want to also hear from you, your perspectives, also from the labor, the trade union side, and what do you think are the implications for trade unions or for workers if ecocide becomes an official offense at the ICC level? So, floor is yours. You have about 5 to 10 minutes, because we are really coming to the end in case we would like to also allow the others to react to you. So, floor is yours. Thanks.
Yeah, thanks very much, everyone. And thanks to the two previous speakers, because I have to say, I'm really an enthusiastic amateur in the field of human rights. So it was great to listen both to distinguished experts, but also an expert who's an elected member of the Belgian parliament. So, so maybe I should just say 2 words about just transition and its basis in universal human rights, and also work that's being carried out by other people in the trade union movement, specifically our colleagues Jeff Vogt and Ruvan Sobasinghe on establishing just transition itself as a human right. Just transition is both a set of outcomes, but also a process. And it's rooted in rights to freedom of expression, freedom of association, the right to effective collective bargaining, and then a range of other rights that are embodied in primarily ILO conventions. And it's the idea that in the process of actually doing something about especially climate change, that workers and our representatives, our organizations, so trade unions and informal workers associations, will negotiate outcomes relating to our jobs together with employers and often governments. And that those outcomes, especially for employers and governments, will contribute to or help to eradicate poverty, protect and defend and even elevate human rights, especially gender rights and labor rights, and contribute to decent work for all, as well as social protection for all. So it's really a very expansive definition or process, expansive outcomes with roots both in human rights outside of labor rights, but also in international processes like the softer processes around the SDGs, and of course what we've just seen in the climate negotiations. And that concept is reflected at the EU level in social dialogue and the EU's commitment to just transition as a sort of pillar of the Green Deal. But we're also getting commitments to just transition at national levels in other countries, such as Canada. There's a commitment in South Africa and so on, New Zealand. So I guess my first reaction after listening to this discussion is that it's very interesting that the crime of ecocide is limited to individuals, right? Because that narrows the scope considerably. And at least in corporate law in a lot of countries, individuals who, for example, sit in a company board are often protected from the consequences, including the environmental consequences of their decisions. The standard can be quite high, for example, in the US, to hold people criminally liable for decisions they've taken as part of corporate boards or corporate management. I think the other reflection that I have is that you were discussing a kind of balancing test of the wantonness of the act, and I think when we start to balance worker rights and also human rights, people's rights to decent wages, rights to social protection, and so on, against environmental rights, I think we've got a hold of the wrong end of the stick. So I'm not contesting the definition of ecocide that was brought forward by the panel. It sounds great. But I'm saying as a practical matter and as an activist and maybe a little bit as a lawyer, we don't want to end up in a situation, which is where we often are, especially in the energy sector, where the rights of workers to a decent new job and social protection get held up as, okay, workers are delaying action on climate change as opposed to looking to where the power lies in these systems and saying that employers and governments are responsible for delivering a just transition as well as emissions reductions. And when they're not doing it, that's on them. It's not on workers. So that's just an issue about how do we talk about these two things together? We should talk about them simultaneously, as opposed to talking about them as two things that might be in conflict. And that also goes back to this definition of wantonness. You will always, we always do find employers, investors, and governments who will say, well, we can't do this because the economic effects would be too big. But there are solutions for that. And there's definitely plenty of capital in the global financial system and in national systems to both bring down emissions really fast, but also to provide people with decent jobs and social protection. I guess the last thing I would say is that just to say what we do in the Just Transition Center, we were set up by ITUC, which is the global federation for most of the world's unions. So we represent about 200 million organized workers in 162 countries. We were set up to deliver the Paris agreements and the ILO guidelines on just transition with unions, help them get good plans for just transition. And we work pretty much only with unions that organize in high emitting sectors, especially, but not only energy, and in high emitting countries. And if we look at this from the perspective of our members, they don't necessarily want to see the CEOs of oil and gas companies, for example, or coal companies in the dock at the ICC, maybe sometimes after a mine accident. What they're most concerned about is that employers are going to change, that they're going to change in response to all these different forces. They're going to lower their emissions, but they're not going to fire a bunch of people while doing that, that instead people will keep their jobs, maybe get new skills and new means of production. And so that's also something, you know, if we're talking about ecocide within our movement, it's important to sort of tease out what the different interests of workers are relative to how do we bring down emissions. Beyond that, I mean, fighting against climate change or fighting for human rights is a fight, it's a struggle on many fronts. And the ICC, as has already been said, was a critical front, especially after World War II, sort of changing the frame for what actions were acceptable and what actions were not acceptable and what consequences might be for individuals. So in that respect, it's pretty amazing that this progress has been made also on the crime of ecocide. Thanks.
Thank you very much, Samantha. Very good reflections, very good points. We don't have a lot of time, and I think I don't even have time to pick up any questions, but I'm just going to let you and you react really quickly, and then we're going to conclude in about 6 minutes.
Really good to hear you, Samantha. It's really good to get your perspectives. I'm really fascinated by what you said about, I mean, there are a number of things, but since time is short, on the focus on individuals. Just to make clear, we were hamstrung by our terms of reference. But to reassure you in a certain sense, and then I'll just make a related point, under the Statute of the International Criminal Court, an individual politician, a prime minister, a president, gets caught as an individual human being. And they can't run as a defense. Well, I was just part of a government that took a decision. And similarly, with an executive of a corporation, it is true that corporate criminal responsibility is not part of the ICC statute. I happen to think that it should have been, but that was a decision taken in 1998, and that ship has sailed for the time being. But I had the very interesting experience a few years ago of giving an advice to a large corporation involved in the production of tobacco products. And I can tell you that for executives of such a company, the idea that on top of civil liability, which frankly, individually, they really don't care very much about because a fine of a few million is just, you know, whatever. What really concentrates the mind is the prospect of a tap on the shoulder for having crossed a particular line. And it was very interesting to me how anxious executives were in the tobacco field that may be withholding information that they had about the consequences of smoking and tobacco products and so on and so forth. That could cause them to be subjected to investigation for a crime against humanity. And I think the same is now going, and I noticed what you said about the oil and gas sector. I've been very careful. I will never give examples because I know the moment I give an example, I'll of that entire industry and the workers of that industry coming down on me like a ton of bricks. But I did an interview for the Financial Times when we came out with our report. And I was asked by the journalist who then wrote a long, you can find it on the web. You just look up Financial Times Ecocide, you'll get straight to the article of one of their very senior journalists. And she pushed me and pushed me and pushed me for examples, a government and a corporation. And I just said, look, I'm really sorry, I'm just not going to do it. That's for others to form a view on. It's for the prosecutor and the judges at the end of the day to decide who they're going to go against. So she said, well, do you mind if I do it? And I said, no, it's your article. You write whatever you want to write. So she chose Mr. Bolsonaro in relation to current events in the Amazon. And then interestingly, she chose the chief executive of ExxonMobil. And I was told by people associated with that company, I know people who work for ExxonMobil, friends who work for ExxonMobil, that caused a lot of pain. It concentrates the mind of a chief executive to really double down in what they are doing when a reputable newspaper, pretty conservative newspaper like the Financial Times, is saying, this is the kind of individual who could be caught. So I totally accept your point. There are jobs at stake also. And I really have been helped by what you've said to think more broadly about the interplay of responsibilities on these issues. So thank you so much for that.
Do you want to react?
Sure.
Maybe?
Yeah, Samantha, I really share your concerns. So I am also convinced that ecocide should be more than just a buzzword. And I completely acknowledge that symbols are very important in politics. We love symbols, but ecocide should be more than that. This new crime should also have a deterring effect in practice to prevent serious environmental damage on the international stage. So in order to do that, I tend to agree with you that the crime of ecocide should also apply to private corporations. And I think we can do that because the definition proposed by the panel, of course, focuses on a very specific instrument at the international level, which is the Rome Statute of the International Criminal Courts. But we can draw on that legal definition at the universal level, adapt it in our domestic legal systems, and actually go further in our criminal codes. So I can tell you, it's not yet official, but I've just submitted a bill to amend our criminal codes in order to recognize a new crime of ecocide at the Belgian domestic level. And that definition also applies to private corporations. I would even say that I think that in the practice, if that is ever to be adopted, that definition will in practice mostly applies to private corporations and not only individuals. And I even think that, and that's maybe another topic of discussion, but we could also apply the principle of universal jurisdiction, which we love in Belgium, in our criminal system, to this new crime of ecocide. So just to tell you that the legal avenues are actually not limited to one forum at the international level. But I think in conclusion that we will need to fight on various stages, and including in every single domestic jurisdiction in order to prove progress on the recognition of this new crime of ecocide.
Can I just play devil's advocate for one last second? Is there not a risk that by putting the corporations into that definition, the prosecutors will say, well, it's less sensitive if we go against the corporation, and we will avoid going against the individual. And that undermines the deterrent effect. Because frankly, at the end of the day, most corporations, fine, they care a little bit, they get a fine, but you can't put a corporation in prison. You can't, go and have a dawn raid on a corporation at 6 o'clock in the morning and take the corporation out in handcuffs. And what concentrates the mind of the chief executive is that she or he or they will personally be subject to a criminal thing. So is there not a risk that you're opening the door?
Can I give you a concrete example of ecocide, which you hate? The Marée Noire of Erika along the coast of Bretagne, Brittany in France. The company, not ExxonMobil, but Total, was recognized responsible for that huge environmental damage. And it was actually fined by the French Court of Cassation, 375,000 euros, which is nothing, and has no deterring effect at all for a company which makes up to, I think, 200 billions of dollars every year. And so I think that the recognition of the crime of ecocide also applying to private firms could have that deterring effect, could actually add this new layer of criminal responsibility for private corporation. And it's not, you know, an or question, it's really complementary. I think we can really do both. And actually, it doesn't even need to be in the legal definition itself. The criminal code in Belgium actually applies in an equal way also to, you know, private corporations, which are just recognized as personne morale, not personne physique, but personne morale. And so that's actually perfectly fine. So I think it's not a battle between the two, but we can actually do more.
I'm very sorry, but I really think that we have to stop. I wish we had more time, and I wish I had the time to pick up the questions. I have myself a few questions, even as being a non-lawyer in the room. But so we have to stop because of the time constraints. But I really thank all of you, Samantha. Also, you are joining us remotely, and we'll be very happy to have this conversation going in the future. And thanks to all the listeners. And I'm really sorry that I couldn't pick up some of the questions. But we're going to think about this issue, I think, in the coming days, weeks, and years. And it will be very interesting to follow that. So thanks again. Have a good afternoon all, and goodbye.
Great.
Wow. I have a few questions if you want to.
Well done.
It's really great.
It's just totally great. Totally exciting.
Yeah, that's really exciting to meet you finally.
No, it's really exciting to hear your story. I was so pleased when I saw the thing in the, you know, it was all over the Twitter sphere.
Yeah.
It's great.
Yeah.
It's really.
We finally made it.
So maybe I can ask you the question now. Because I was wondering, like, what